possible for an attorney to steal money from an estate in probate? Literally, no. Now, you can run into issues where, lawyers who are not operating within their fiduciary responsibilities may do essentially what's akin to stealing, which would be, overbilling or, taking a commission that's not their fair share, that sort of thing. It may seem like stealing, but it's not literally stealing. But generally speaking, no one can, steal money from an estate in probate. In North Carolina, everything is sort of checked and overseen by the clerk of court and the many employees within that department, deputies and assistants. They're basically overseeing the administration to make sure that it's consistent with state law and consistent with the rules in place, whether that's the rules of intestacy in the absence of a will, or the rules of the will itself, if there is a will. And so that pretty much precludes anybody from, quote unquote, stealing from an estate through the probate process. But it doesn't mean that people can't favor themselves. Generally, it's pretty hard for a lawyer, unless they're actually serving as the personal representative of the estate, to pay themselves or to do anything sort of unilaterally against an estate, because they're usually in a support role. Usually lawyers represent executors or administrators in the administration of the estate. They're not actually the ones cutting checks or getting access to funds. That's always going to be, there's always a potential for a lawyer to serve as the personal representative though. But generally speaking, no, lawyers can't serve or can't steal money from an estate.